Over the years, I've worked with or sat on the other side of the table with many of you who know me as a transactional lawyer with expertise in university licensing. That's why I'm sitting here. I head the corporate and licensing group of Cohen, Zedek, Latzer, Baratz, Israel's leading IP firm, with offices in the US and in London, and in Tel Aviv, of course. I'm thrilled to introduce Conna Weiner, who is an international mediator and arbitrator. As opposed to numerous litigators who do not have a deep understanding of commercial issues, Conna has a wealth of experience in negotiating and drafting contracts as a former in-house counsel at big pharma such as Novartis, Mylan, and Shire. We met a few years ago when my firm represented Herzog Hospital in litigation in both the US and in Israel against a US pharmaceutical company relating to IP in the pharma field. The rest of the story is confidential, but I met Conna, who mediated the complex settlement that eventually reached between the parties, and was very impressed at her contribution to ending a long and bitter dispute. My role was to reflect such understandings in numerous contracts to the mutual satisfaction of the parties. Here again, Conna's contribution was invaluable. When Tommy, Karen, and I came up with the topic for the session, I could think of no better partner than Conna to join me to discuss the prevention and resolution of disputes with industry partners. Conna, perhaps we can start by you introducing yourself and explaining the differences between mediation and arbitration.
Hi, well, thank you very much for permitting me to speak to you via remote means. I really wanted to be there today. I've never been to Israel. I will get there eventually, someday soon, after all of this crazy COVID pandemic stuff that has subsided. Can you hear me, everybody? Thumbs up? Okay, good. So I'm very grateful to Yael for having me here. And I also just want to start out by saying that as a result of my background, I have tremendous respect for what you all do. The academic industry interface is a very, sometimes a very difficult landscape, but it has brought so much innovation to the world in so many fields, including life sciences, where I specialize. And I greatly appreciate and understand the difficulties that you face every day, the time pressure that you're under, and it's a wonderful thing that you're doing. The industries that benefit from the basic research that academic institutions do, it's just a wonderful thing. So I appreciate, given my 20 years in the industry, everything that you're up to there. So thank you for that. And you know, Yael, I think you were telling me that the tech transfer industry and institutional structures really got started in Israel well before they did in the United States. You know, it took a big act of Congress, the Bayh-Dole Act in 1984, for US universities to get permission from the federal government to give exclusive licenses to commercial partners. So we were behind the 8 ball. Isn't that right?
That's absolutely true. The Israeli TTOs were established way before the American ones, and it is quite amazing to see them among the top 10, including the top 10. I think Yisum was included in that in the world. It's really quite impressive.
Well, that another reason I'm honored to be speaking to all of you experts today. So I wanted to just say a few words about how I come to all of this, and then perhaps if you go away with nothing else today, you will never confuse mediation and arbitration again. That's one of Yael's and our goal. One of our goals is to make sure nobody in this room ever makes the mistake that many very, very sophisticated lawyers often make. So, but before I get there, I did start out as a mean, nasty litigator in New York City. No argument was too small. And I learned as a result of doing that there had to be a better way to resolve disputes than going to court, especially in the United States, where cases can take years and years to resolve, and they're very expensive, and it's not about business. It sets projects back as people fight. So I then went in-house to, as a lawyer, to various life sciences companies, most notably Novartis. I'm going to date myself a little bit. I started out at the old Ciba-Geigy, and Ciba-Geigy merged with Sandoz, some of you may remember, to form Novartis. I've also worked in biotech. I was a general counsel for North America at Mylan, the big generics company. So if it has anything to do with drugs, at least legitimate drugs, I may know something about it. And also diagnostics and medical devices, all of the life sciences. And there I was forced to become a transactional lawyer, to put my litigator ways aside and learn how to get along with people and do deals, a very different way of being a lawyer, which was very gratifying. And as a result of all of that, I learned a little bit about how to resolve disputes between collaboration partners and industry and academic partners. I'm very familiar with the space. And so, Yael and I are hoping to share some of our experience and help you avoid disputes in connection with our presentation today. But some of I guess if I had to put dispute resolution on a continuum, with all my years of experience, and I've been a mediator and an arbitrator now for about a decade, 10 years, the best thing you can do is try to find a way to use what I call self-help without hiring a mediator or an arbitrator or going to court, but building mechanisms in your contracts and in your relationships that help you avoid disputes in the first place. And some of those mechanisms that have come up in the life sciences include alliance management. I did a deal many, many years ago with two big, Novartis and another big pharma company. It was in the 1990s, and we had hundreds of pages of agreements that we negotiated. It was a research development and commercialization 10-year anticipated collaboration. And after all the documents were signed, I got a call from somebody who I'd never met, who worked for Novartis, who said, "Hello, my name is Felix, and I'm your alliance manager." And I said, "My what?" So alliance management has been a professional field that has developed in connection with the management in big pharma of complex transactions, and they're employees of the companies. They're not neutrals like a mediator, but they're employees of the companies, and their job is to help avoid disputes. So that's one form of self-help that's been developed in some very large complex deals. Or you may have heard of a relationship manager, having somebody involved in the implementation of the relationship whose job it is to make sure that there aren't miscommunications, to surface issues that might cause a dispute down the road. And another mechanism like this is building a set of committees, steering committees that will help manage development, help manage research, make decisions, and help keep the relationship on an even keel. But sometimes, Yael, we were chatting in preparation, sometimes steering committees are ignored, or they just don't work out. That's one of our themes here today too. People negotiate things, and then what happens to them? What's been some of your experience with these complex steering committees?
Well, I think that it's part of the general problem of contract administration. In the US, there's actually a job description, contract administrator. So I haven't seen that here. I think it's missing in a lot of the academic institutions because there really are so many details to follow up in agreements, both from the licensor side and the licensee side. And very often when, especially when there are disputes about diligence, for example, so I'll ask, let's say if I'm representing the licensee, well, let's see the development reports that you've provided over the years to the licensor, and then it turns out there were none. And so not only did the licensee not prepare them, but the licensor didn't follow up and didn't ask for them. So it makes it harder in some cases to try to understand what the relationship was like and where you can find some kind of an argument to even to claim, well, there was certain knowledge on the part of the other party what the situation was. You just have a big void and there's really nothing you can do. On the other hand, a few years ago, I had a funny incident also with a licensee who undertook to pay royalties on a country by country, product by product basis, which is the formula that academic institutions prefer. So it turned out that although he was supposed to have been paying 10 years from the first commercial sale, here we were 15 years later and he was still paying. So it works on both sides. But I think it's a neglected area here. I guess it has to do with budget, like any other thing. Like, you know, if we all had bigger budgets, we'd have alliance managers and we'd have contract administrators and all those great things. But I mean, I still think it's something that should be given, that some thought should be given to, because you can do a lot of self-help along the line if you actually follow up what's going on between the two parties.
Yeah, absolutely. And I guess that's another theme you're going to hear throughout our discussion today is the importance of monitoring these contracts. You cannot do these contracts and then shove them in a drawer and ignore them. You work so hard to come up with rights, termination rights, and the whole 9 yards. And somebody's got to be periodically looking at these things, also in connection with meeting your obligations. All right, enough. We'll go through some more specific examples of that in a minute. So now
we'll be here all day.
Yes, exactly. We'll be here all day. Yes, that's right. So but let's move on to, okay, so you've done all the things we're recommending. You have an alliance manager, you have a contract administrator, you've tried to have good communications, you've been doing your steering committees, and then you still have a dispute with an industry partner or somebody else. How do you best resolve that? I'm here to tell you that litigation is possibly one of the worst ways to approach resolving a dispute. It instantly changes the cast of characters. It makes everything more hostile because people are in their war zone mode. And there are many ways short of litigation to try to resolve disputes more quickly and efficiently. And one of them is mediation. So let me just contrast. I promised we were never going to confuse mediation and arbitration again. So what are the differences between those? Mediation, and I do both of these things. Mediation is hiring a third party to help you negotiate with the other side. It's not binding. It's confidential. And if you hire someone who knows licensing and who knows the field, they can help with their experience by letting you know perhaps potential solutions to a problem.
Or a patent attorney, or a patent attorney. Which
or
is
a patent attorney, right.
Useful. Yeah, go ahead.
Yes, exactly right. So often in a mediation, in a litigation, you have two choices. You win or you lose. In a mediation, you can help you can use a mediator to help you, in effect, renegotiate a contract that hasn't worked out through an amicable settlement. Now, just a quick word. Some people say, look, I've been trying to resolve this dispute with the other side for 2 years. I get this all the time. Now, why is it, if you come in, why isn't that going, well, why is that going to be helpful when I have not been able to do this through direct negotiations? Well, the idea is when you have somebody who's neutral, who's paid by both parties. I always tell the people I work with, you're both paying for half of, you're paying for half of me, each of you. So I am going to listen in a way that is neutral. I'm not going to take sides. I'm going to point out strengths and weaknesses in the arguments. And here's one very important psychological point. Sometimes when you get into a fight with somebody, now let's include the home front, for example, your spouse, and you're angry at them, if they say something or they take a position, you might engage in a psychological mechanism or phenomenon called reactive devaluation. It's a proven psychological phenomenon. Some of you who have taken negotiation courses may have heard of this. If you hear your enemy say, this is a good solution, you're going to say, aha, they must have a hidden agenda. You reactively devalue that person's suggestion. So I can come in and make suggestions about how to proceed based upon my experience. And I'm neutral. People trust me. They understand I'm just trying to help. And so that phenomenon goes away. That's very common in extended direct negotiation. So as a mediator, I have no authority to make anybody do anything. I only have the power of persuasion. And it's really up to the parties to come up with their own solution. And I have to say, I'll just make this statement. It's my opinion. There is absolutely no good reason not to have a mediation clause in every significant contract and even smaller ones, because it makes people hit the pause button, bring in a third party, and sort of reset and rethink things. And it's non-binding. You have nothing to lose. But, Yael, I was very surprised to hear you talk about the fact that mediation is not as common in Israel as it is in the United States. I wondered if you wanted to comment about that before I said a quick word about arbitration.
Yeah, I don't think it's that common. I mean, some of the participants here may have other experiences, but it's not very common to find mediation clauses in our contracts. I think that, again, since we all live on a smaller scale here, maybe in the US, there's also a cost consideration, because at the end of the day, bringing in a third party does cost. There's also a time element where maybe there's a certain suspicion that maybe one party may use that to their advantage by buying time through mediation. I don't know, it's just not part of the local culture, although it's become more and more common when cases reach litigation. It's very common for judges to try to take the dispute out of the court and move it to a mediator in an attempt to end the dispute. What I do see very often in larger contracts with big corporations is sort of a step-up process, which says that before either party can resort to arbitration, the dispute must be brought before the CEOs or some other high-level executive from each party, so that somehow the process doesn't run away, and it has to go get management attention before it accelerates into a full-fledged litigation. So I think that is a helpful mechanism. So maybe you'll talk a little bit about arbitration. And,
right. Absolutely. And I just wanted to pick up on what you just said. That has a name, what you just said. It's sometimes a multi-step clause, waterfall clause. Sometimes it'll have three parts: negotiation, mediation, arbitration, or negotiation, mediation, litigation. And, I just think that middle step, all of you professionals ought to give that a think, because you can control the time and cost, but we don't have to. I could, talk about that for 3 hours, and we don't have that. So arbitration is completely different from mediation. I said, as a mediator, I had no authority to impose a solution on anybody. I'm not picking a winner or a loser. I'm just trying to help people come to their own amicable resolution of their own dispute, and they remain in control. As an arbitrator, I'm a private judge. I'm going to pick a winner and a loser based upon the applicable law, and that's it. An arbitration result, it's confidential, it's quicker than litigation, so it's better than litigation. It's final. You really cannot appeal an arbitration result, and that no pun intended, appeals to many CEOs. I had a CEO boss once, who said to me, and he had a Scottish accent, which I'm not going to imitate. He said, "Conna, I'd rather lose quickly than win slowly." And what he meant by that was, if he was going to lose a case, he'd rather get it done rather than spend years in court winning, which can feel like not winning, even if you win after 2 years of litigation expenses. So that is, I think, a very healthy attitude about arbitration. But it is, make no mistake, you are getting the equivalent of a court case. You put on evidence. I can't talk to the parties on an ex parte basis. I'm very distant from them, as opposed to a mediation, and I make a final decision. I'm finding the facts. So those two things are very, very different, as you can see. And we do recommend arbitration over litigation still, but do think about that mediation step. So that in 15 minutes or so, that's the dispute resolution scope. There are all sorts of other things you can do. You can hire independent experts about accounting issues, but the whole point is, use all of the mechanisms that you can to assume that disputes will come up, and put mechanisms in your contracts to deal with them that don't involve expensive litigation. And you will be much happier, and your institutions will love you for saving money. All right, so I think we can next go into our.
I just want to ask you a question.
Oh yes.
How long do you think should be afforded to mediation? is it realistic to say that the process can be completed, let's say, between 60 days? Because you don't want it, again, to be abused.
Right. Well, like I said, mediation is totally within the hands of the parties. It's their process. So it can be as long or as short as they think it is valuable. I've often seen in a clause, the requirement to try it for 45 days, and then you go on to the next thing, be it arbitration or litigation. And the parties can extend that. In some of the cases we worked on together, Yael, that took a long time, but that's because the parties thought it was worthwhile, and it was a very complex situation. I think that one took about 6 months, but with everybody's agreement, and it avoided what would have been a 3-way, multi-country, multi-jurisdiction set of litigations. That was the alternative in that case. So it's all a balance, but it can be done very quickly and efficiently.
Don't you think that arbitration, though, is also something for the rich? Isn't it expensive?
It can be very
Also,
expensive.
it depends how many arbitrators, like I've seen ICC arbitration clauses and people don't think about it. A panel of 3 arbitrators, it costs in London, it's a fortune, right?
It is a fortune, yes. And again, we could also spend 2 or 3 hours on a properly drafted arbitration provision, but there are things you can do there to save money. You can have 1 arbitrator instead of 3. You can say the arbitrators are required to render a final award in 6 months. You can build a timeline into your clause. That's one of the single most effective ways to save money in an arbitration, is to force everybody to get it done in 6 months to 12 months. Those are 2 ways to save money, and there are many others.
If it doesn't happen within 6 months, the parties are released from the obligation to arbitrate.
Yes, that can be one of the things, or it's null and void, etc. The effects of that not happening, I have not had that experience, because people generally comply with the clause, right? And yep. And I think, you wanted to talk also about governing law. That's a big issue, isn't it? I think.
Yeah, because if you have 2 Israeli parties, then the governing law will be Israeli law. But if you have a foreign party, it becomes a lot more complex. And of course, the desire is to find a neutral law. But again, as I mentioned before, if you choose London with 3 arbitrators, it'll be so expensive that you won't be able to do it. And I think that also there are a lot of differences between the laws that people don't appreciate. For example, I think New York law, for example, is a favorite because everybody likes to go to Bloomingdale's. But the thing is that New York law, people need to take into account, is very rigid. Maybe Conna can elaborate on that. But so maybe talk about New York law, and then I'll explain the difference between Israeli contract law. So go ahead.
Sure. Well, when I was in inside counsel, one of the big questions we all.
Oh no. It was going too well. Yeah, sure.
About mitigation.
About what?
Mitigation.
Mediation? Yeah, okay. Mitigation is another thing that you need to do if you're
Sure.
in a
Mediation.
dispute. Yeah.
Do you think there's advantage to be a psychologist and not a lawyer doing that?
I think every lawyer has to be a psychologist to a
So,
great degree. I think it's a lot of what we do.
Are you familiar with psychologists in this field?
Oh, people who are really psychologists or trained psychologists? Maybe we need some psychiatrists. I don't know. I don't know. Let's you know what? We'll ask Conna. No. The answer is no. I haven't heard that one yet. Maybe in matrimonial law it would be a good idea. But I don't think in high tech. I don't think it's. Although I must say that every lawyer has to have certain talents in understanding the positions of both parties in order to reach a meeting of the minds. I think it's very important. Conna, are you back? Oh, she's connecting. Well, in the meantime, I just want to say that there's a big difference until Conna gets connected here. And I'm not saying that you shouldn't choose New York law, but I think that one thing people should be aware of is there's a very big difference, because the attitude of Oh, yeah, here you are.
Back, but you are not there, so I can't see you, but if you can hear me, I can talk. Were you talking about, there you are. Were you talking about New York law?
Well, I answered a question, and the question
Oh,
was,
okay.
do you ever encounter mediators who are trained as psychologists? So I couldn't answer that one. I haven't.
That's a very good question. I've actually had some training in that field. I think it's important to have some training in the field to understand some of the basic concepts. And there are mediators who have had a fair amount of training. It's especially important when you're doing family law mediation. It's something I don't do, that's a little bit different.
Yeah, okay. Yeah, so go ahead, maybe give a little bit of an overview about New York law, and then I'll do my comparison to Israeli law. Oh, no, she's gone again. Conna? All right, until Conna comes back, I'll say what I wanted to say, which is that under Israeli law, you have concepts that aren't recognized in New York, for example, and that is because our contract law is based on the German contract law. Because the Israeli law is a strange combination of things we've adopted, bits and ends from all over the place. So we actually have the German contract law, which recognizes an obligation to negotiate a contract in good faith and to implement a contract in good faith. So in New York, you don't have that wiggle room. What you see is what you get. What it says in the contract, I mean, the judge will do the utmost to just interpret what the intention is, and it doesn't matter what you said extraneously in the course of negotiating it or in implementing it. So I think it's a very big difference that sometimes Israelis don't appreciate, but it still doesn't mean that you will get your counterpart to agree to choose Israeli law. That probably won't happen. So,
I'm back.
Okay, so Conna, you're back. Wonderful.
I'm back, and I've switched my internet provider. So I suddenly had to teach myself very quickly how to do that, but virtue is the mother of necessity. But I just wanted to say, New York law is very, very strict about contract interpretation, and that is one reason big pharmas often choose it, because what you see is what you get, right? When you draft a contract as a lawyer, you want to know that those words are going to be enforced. And maybe Yael, while I was busy figuring out how to change internet providers on the fly, maybe Yael talked to you about the concept of the four corners of the agreement. That is a very well-known, often cited New York court principle. What are we doing when we're trying to interpret a contract? We're trying to interpret what, as an arbitrator, what did the parties intend, right? I can't rewrite the contract. What did the parties intend? And there are various mechanisms that courts use to try to figure that out. And in New York, the first place you go to is the four corners of the agreement, the words on the page, and a court is extremely reluctant to stray beyond that to concepts like good faith, although we have that implied duty of good faith and fair dealing. The courts really want to look to the language of the agreement, and only if there's an ambiguity will they look at what is called parole evidence, things like what the parties negotiated before they wrote everything down. I was a general counsel in Switzerland, and as a New York trained lawyer, I was shocked, amazed, and horrified at the idea that in Switzerland, they actually looked at the conversations before everything was written down to figure out what the intent of the parties was. This was so horrifying to me, given my background. And I do think there's some benefit to doing that, but that's very important. If you've got New York law in a contract, you're probably going to have a longer contract because things really need to be written out, or in Delaware, things really need to be written out. So be very careful about the implications of your chosen law.
Okay, great. So now I think after this long introduction, let's get on to the actual subject matter, which is preventing and resolving disputes with industry. So again, prevention is key. And as we've heard, the best way to achieve that is through crafting clear arguments. Clear contracts, sorry. Conna and I sat together in New York, which was a lot of fun recently, and came up with the top 10 issues that we found come up in disputes relating to licensing agreement. So the first one, maybe Conna, you want to start about what you call framing the issues.
Sure. I said a little bit about this earlier, so I'll just quickly touch upon it. What I have found as both a mediator and an arbitrator is that when academic institutions and industry partners negotiate, there's a real difference in a sense of perspective about the value that each side is bringing to the table. So the academic institutions understandably highly value the basic research that their researchers are doing, the idea, the invention. That has a lot of independent value. It does. But for an industry partner, the idea is, well, you can have all of the ideas that you want, but they're not worth anything unless you can commercialize them. And they're not going to be commercialized unless I, the industry partner, put lots of investment and do additional studies or clinical trials in the case of pharma. So my contribution in terms of how much money is going to come out of that idea is, in a sense, and I'm just telling you, I'm the messenger here, much more valuable than your contribution. So those two perspectives often clash in arguments about milestones and royalties and sublicensing income. I just wanted to set that table for you because it comes up all the time in disputes between these two sides.
Yeah, and way too often universities really are in a position where they're licensing out basic technology, not applied technology. I mean, I think that's one of the biggest problems. It's and that very often fails because it hasn't been tested. And I actually taught Conna a new expression that we use here, which is called the valley of death. You know, bridging between the basic science and applied science. And luckily, in the Israeli ecosystem, there are a lot of attempts to try to bridge that. I think that we just heard those who heard the head of the IIA speaking. There are lots of new programs, not only Cohen, which a lot of you, I'm sure, are familiar with, where the IIA funds basic science and tries to bridge it over to applied at the universities. But now there's also a seed project where a university can license very basic technology into a startup company, and then there's an investor. I just finished doing one of those now, and it's a new model. So luckily, you know, they've been very creative in trying to find solutions to this problem. I think what I would like to encourage, which unfortunately I don't see enough, is early stage collaboration between academia and industry that precedes the actual licensing, because I think that a lot of grief, you know, could be avoided if there was some kind of a joint feasibility program before and out everyone goes to the trouble of negotiating one of those 40-page license agreements. And I think it would be helpful to both sides. So the risk would be smaller for both parties, and the academic institution could benefit from the additional funding, because maybe even something not anticipated would come out of that kind of program. So unfortunately, I see that very often. I've seen research institutions, you know, holding back from allowing that kind of scrutiny from industry. And I think I hope that that'll change over time. So in any case, if we go to the 10 points that we identified, the first one is know what you're licensing, because that's really the most important thing to define. Do we have patents, patent applications? Do we have know-how? Do we have proprietary material? Sometimes that's overlooked, and that really merits specific attention and treatment. You know, one case I like to talk about without mentioning the name of the research institution so as not to embarrass them, is that I was approached by a company that had acquired a licensee, and they were complaining that the provisions were very unreasonable, and that the company that they had acquired was still paying royalties even though the patent had expired. So I opened up the contract, and the know-how exhibit was blank. No one bothered ever filling it out. So after my first letter, the party settled. You know, that was the end of the discussion. So unfortunately, very often, you know, the lawyers really work hard to, you know, cross all the T's and dot all the I's. But then when it comes to the exhibits that the client is supposed to prepare, sometimes those are faulty, which is an understatement. So I think it's very, very important to make sure that your researchers give their full attention to that. And another question here is also besides identifying it, how long will the licensee have access to know-how? Because again, the licensee is not buying the lab, so you need to really define that. And there can be a lot of arguments about competition and what's due to the licensee who's putting a lot of money in the project and doesn't want to see the same researcher competing in the same field. So these are very, very tricky things that merit a lot of attention, and they're definitely, seeds for later disputes. Conna wanted to talk about other aspects of that.
Sure. Well, those are all very important points. I just wanted to raise one issue that may come up in connection with the other 9 topics we'll go on to talk about. And that is, there are often disputes that I see as a mediator and an arbitrator when something doesn't work out. All this work is put in and there's a technical failure. The diagnostic doesn't work, or the pharmaceutical product does not produce the therapeutic results that were anticipated. The medical device has a glitch. And I see these cases because there's an assumption that if something didn't work, somebody must have done something wrong. Either they were negligent or they committed fraud in the first place because they made promises that were not appropriate given the early stage of the technology or the promise of the technology. And this is particularly true with some pharma companies. And what I try to tell people in these disputes is that there will be technical failures. I mean, we're in a very high risk industry, and just because something doesn't work doesn't mean that somebody did something wrong. I said what I have just said in about 20 mediations. Okay, so the idea is you need to provide for mechanisms that break up the deal on an amicable basis, divide up the know-how that's been generated, the data that's been generated, whatever has come out of the collaboration or the license to date. Don't end up getting in a fight with an industry partner because something hasn't worked. Just have understand that that's going to happen quite a bit of the time, especially the earlier in the technology research and development cycle you are, and provide appropriate mechanisms to end the relationship rather than fighting about it. So that's I think what I wanted to say about that. And also be careful about manufacturing. Manufacturing challenges, scaling up, knowing how to make in commercializable size the product or the diagnostic or the device, that just generates a host of additional technical problems and possibilities of technical failure that need to be monitored. Again, here we are back on our favorite subject that Yael and I are harping on for you, is the need to monitor the diligence of your licensees. They're going to be off there hiring third parties to do manufacturing and encountering hosts of additional problems. And you need to be able to figure out, okay, are they unable to manufacture this stuff and therefore give me my royalties because they didn't put enough effort into it, or because they were negligent, or because they're simply having problems? That's a downstream activity that will directly affect your ability to make money from your IP that should not be ignored. The end.
Yeah, I mean, even though the contracts that the academia usually uses include a very wide breadth of disclaimers, we have nothing to do with this later on. We gave it to you as is. It's your responsibility. Indemnify us if something goes wrong. You always need to take into account that every patent inherently includes some form of a promise, and you have to be very careful also what your researchers say to potential licensees as to the downstream success of the patent or the commercialization of the patent. And these things, because in Israel, again, there are doctrines of good faith and unfair dealing, These things have come to court despite all the indemnification clauses. I don't want to go into specific cases, but these arguments are made all the time. So you really need to be careful about that. Okay, so that brings us on to number 2, which is the issues of inventorship and collaboration and overlapping research. Conna.
Well, I will have to say that this issue is number 2 for a reason. Isaac Newton, the famous physicist, once said about scientific discovery and invention, if I have seen further than others, it is because I have stood on the shoulders of giants. So what does that mean? If I have seen further than others, it is because I have stood on the shoulders of giants. That means that all science is iterative. There's nothing new under the sun, despite what your researchers might say. And that means also that there are overlapping discoveries that often lead to disputes about who discovered what. And I can tell you there is nothing more emotional than an argument about inventorship, nothing in the IP and licensing field. So as tech transfer professionals and the attorneys advising them, your job is twofold. One is you need to keep track of what your researchers are doing. Yael and I met in connection with a very complicated dispute about who invented what. And 2 researchers had worked together in Israel and the United States. They worked on the same compound. They worked in overlapping therapeutic areas. And I don't have to tell you, this just resulted in some arguments about who had a right to license and patent the things that they had worked on together. So keep track of what your researchers are doing and with whom they're working. Make sure you have very tight material transfer agreements. Make sure you have very tight confidentiality agreements that keep some, that are very clear about what your rights are versus the people that your researchers may be working with, okay? It will result in disputes if there isn't clarity. And that's all I'll say about that particular matter. You should define joint ownership. You shouldn't rely on the underlying law because the laws of ownership of patents and other IP, they differ from jurisdiction to jurisdiction. So let's just say, hypothetically, and it's not so hypothetical, that a researcher that your researcher has been working with goes ahead and files a patent outside of Israel, say in the United States. All right. So what laws apply? How do you define joint ownership? You need to say, the laws, joint ownership will be defined in accordance with the applicable laws. That is the worst possible clause. This is from me coming as a mediator and an arbitrator. Applicable law. You don't know what you've got. You don't. You should say laws of X at the time that the contract was drafted, or define it more clearly using whatever language you want. But applicable law, I wouldn't not recommend because of these issues. I mean, Yael, I'm sure you can.
What you find here usually is U.S. patent law for that purpose. And I also want to make a remark here that, Conna said that there's no wrath between 2 inventors fighting over an invention. You also need to take into account that if you name an inventor who's not really an inventor just because of his stature or ego, that could, down the road, that could invalidate your patent. So that kind of pressure is totally irrelevant, and people need to be to take that into account. I'd also like to take this opportunity to correct a misconception that I also find very often among people, even people with experience, and that is what is a joint patent? So sometimes you see people draft, the patent will be owned as follows: 80% by X and 20% as Y. It doesn't work that way. It's undivided ownership. It's joint. Each party has an undefined percentage and it's joint. The issue of percentages relates to how you allocate commercial rights, not ownership rights. Okay, so that mistake often comes up. Now, also that leads me to also mention the importance of good interinstitutional agreements. because I mean, I've seen a situation where there was a fight among the researcher, and then one institution was almost powerless to actually commercialize the technology. So it's very important to give authorization maybe to one party to conclude agreements. There are also complications when you have a few research institutions and only one of them, for example, does sponsored research. There could be additional inventions or additional IP that could be bundled together. So it's very important to have here maybe have a mediation mechanism on how you allocate percentages to each contributor. Okay, so then that leads us to our next topic, which is the whole issue, and it ties into what we mentioned before. What are you actually licensing out? So because you have a lot of arguments with parties about future inventions in the same field, and which could have or be necessary or useful for commercializing what they licensed in. So we have a few mechanisms that we see, and I just like to quickly run through the three because there are a lot of misunderstandings about that as well. So the first one is a right of first look, which means that you have to inform the licensee if there's something that could be of interest to it, and then the licensee can look at that invention and see if it's interested in starting some kind of a dialogue about licensing, but there's no obligation to actually license. The second one is the right of first negotiation, which means that there's a period of time afforded during which there's exclusivity to reach an agreement. And the last one, in which I really recommend against, is the right of first negotiation. Because if you give someone a right of first negotiation, what that means is that you have to actually give them information about an offer that you receive from a third party. So you'll never have a negotiation with a serious third party. So right of first refusal, sorry. Yeah, sorry, I went over. Negotiation was the second one. The third one was right of first refusal. So again, in the right of first refusal, you have to actually disclose the details of a bid made by a third party, and no serious third party will enter into a dialogue with you if they know that someone else has the right to step in first. That's a very big mistake that I found in contracts with various transactions and collaborations, and down the road it can become a very big problem. So that's something I definitely recommend against. Conna, you wanted to talk about other downstream issues.
Well, I just want to emphasize that these three things that you've talked about, especially the right of first refusal, are a source of many disputes in mediation and arbitration. I think I have now at least 2 pending arbitrations where I'm sitting as an arbitrator, including a gigantic ICC case where whether or not the licensor met the requirements to bring downstream deals back to the original licensor first, whether or not they breached those agreements and obligations, it's a source of a significant part of the arbitrations. And it can be sometimes difficult depending on how you sliced and diced the definitions of field and territory. We'll talk about that in a second, to determine whether or not you violated it. And again, remember the theme that we're harping on throughout is the need to monitor and do contract administration, because somebody in your institution needs to have in a database a list of all of the rights of first look, negotiation, or refusal that your institution has entered into. Remember, these contracts have a lifespan of potentially a decade or even more. So somebody's got to be in charge of remembering what you promised to do to your current crop of licensors as your licensees, as you're going out and licensing additional fields for the same compound or additional compounds, because it's really easy to get tripped up very innocently on those sorts of obligations because of the time span of the license and the relationship and sometimes the bad drafting of the right of first refusal or negotiation in the first place. So I'm just telling you, this is one of our top dispute issues because it comes up in mediations and arbitrations all the time.
Yeah, and some of you may not know what the researcher is doing in his lab, which makes it even more complicated
Yes.
because you need full cooperation with the researcher who may or may not like the licensee later down the road. So it's an issue.
Yes.
So you want to introduce the next number 4?
Sure, it flows from, I almost already talked about it, which is a good thing since we're only on number 4. So number 4, a scope of license. Again, this is another area that comes up in mediations and arbitrations all the time. Remember, I'm sort of the voice of doom here. Because of what I do for a living, I'm seeing the things that turn into a mess, and we're talking about them so you can perhaps avoid these messes. So this is, again, drafting and monitoring. Are we sounding like a broken record? Drafting and monitoring. If you don't carefully define what you've licensed in terms of the field, the definition of field, capital F field, you can have a compound, pharma companies do this all the time, that you license out to various parties to do different things. There's nothing wrong with that, but you need to very carefully define that field. And here's where a little science background comes in very handy. I'm sure many of you tech transfer professionals in the audience have a science background because it's incredibly difficult to appreciate the definitions of field if you don't understand a little bit about chemistry and biology, esters, salts, etc., so that you know what you're licensing and you can appreciate whether or not the draft is clear enough. And territories also get a little messy. I've seen conflicts between licenses for Asia and then licenses in another contract for parts of Asia. And nobody made the connection because, again, that's sort of that's not just a drafting issue, but it's a monitoring issue. Is Asia going to pop up in your database in connection with another license that's just for Japan, right? It sounds silly, but when you're licensing out hundreds of compounds for different uses in different territories, it can become a real management issue. So I've seen fights about this whether or not scope of license or scope of territory exclusivity was breached constantly. And again, drafting, monitoring.
Well, I think that on the other hand, what you need to take into account is that limiting the field, on one hand, it's important if you have, let's say, a platform technology, and obviously, right, if you're licensing out to a small startup, they're not going to have the means to bring a lot of applications to the market. However, if you're too stingy with the field definition, that also can kill incentive down the line. And I've seen cases where I've seen a case where a company started development work. Actually, I've seen this more than once, and they found that the IP that they licensed in really didn't do the trick, what they thought, what they wanted. And only because of a field definition, they decided to terminate the license because of the restrictions, because, in one hand, they said we would have liked to have the affiliation with the prestigious research institution. It's good for us to say that we're a licensee. On the other hand, we didn't get anything, and our research has taken us beyond the field. And if we continue with this license, then we'll be barred from actually, because if we implement our own technology, the licensor will say that we're surpassing the scope of the license. So it's a tricky situation. It's a double-headed sword in some ways. Another thing I wanted to mention also is that when you have multiple licensees, it brings up other issues such as, for example, who pays for the maintenance of the patent? What happens if there's patent infringement? There could be a big conflict of interest here between various parties. So it could be a recipe for a lot of, and what happens upon termination of the agreement? Can the IP go to another licensee? So there are a lot of issues around that. Which brings me to number 5, which is another biggie, and that is diligence. That's always really draws a lot of attention in negotiating contracts. What is the diligence measure that can be used for termination or reducing the scope of a license? And here, the big pharmas like to revert to something very vague, which is very hard to put your finger on, which is commercially reasonable efforts. So maybe, Conna, you want to expand on that?
Yeah, well, absolutely. And the standard for commercial diligence, for example, how much effort you're going to put into something before you get the license back. You know, a pharmaceutical company does not want to be told by anybody how to do business. And a big pharmaceutical company like a Novartis or any other big pharmaceutical company, their business will change over time, and they only want to have an obligation to do what they would have done with a similar product with a similar market potential. You probably have seen those definitions of commercially reasonable efforts, and that's perfectly understandable. It's a very common standard. They don't want to be restricted in how they do business. They may have other priorities down the road. So, but that's the precise problem for a licensor, that flexibility. I guess what I would say is understand that that may become an area for disputes. And talk, you know, Yael talked about exhibits for know-how. If you can get your industry partner to agree to some objective metrics in an exhibit for how to determine commercially reasonable efforts, that can help avoid disputes down the road, and you can sell it to them.
For example, let's learn how. For example, can you expand on that? What would be?
Sure. If you like, let's say you for commercialization, a pharmaceutical company will have a sales force, and they will have a certain number of products that each salesperson will be responsible for promoting. And you can say, or even in research, you can say the company will develop FTEs, will devote this number of FTEs, full-time equivalents, to this project. All right, you can, that can be either commercialization or research, or you can have budget requirements. The pharmaceutical company will spend X in connection with the research and development of my technology, right? So that, and then that will be considered commercial as part of commercially reasonable efforts. They'll resist that. But what you want to do is say it's only going to avoid disputes down the road. And if you have other competing licensees, potential licensees, you can use them to leverage. You know, anybody that meets my objective is willing to come to meet these objective criteria in this exhibit that help define commercially reasonable efforts, gets the deal, right? So if your leverage is good, the higher your leverage, the more competitive the bidding process for this technology, for the technology you're licensing, the more you'll be able to get. But it's, you know, it's budget, it's resources, FTEs, any objective measure you can get them to agree to. So those are two examples.
Helpful. Yeah, so I want to talk about the benchmarks that sometimes we do see when we manage not to be satisfied by commercially reasonable efforts. So one is the regulatory milestone. So I just want to raise in this context that once it was very clear there was phase 1, phase 2, phase 3, and that's it. Now there are all kinds of intermediate phases, and I recently had an argument with a licensee who was in stage 1. You know, there's 1, 2A, and there's 2B, and there are all kinds of like transitions, automatic transitions between phases. So I think that, you know, it's something that really merits more attention as we move into new contracts, because it's very unclear. You know, they aren't the same. Like, for example, there's now a track where you just transition from stage 2 to stage 3. There's no endpoint that you can identify in this process. And then the question is, when did the licensee actually meet a milestone like that? It's very problematic. I had a big argument with the licensee over that, and I haven't managed to find clear regulatory opinion on the subject. It's a very strange situation. So you need to define very carefully what you mean as to each phase. If it's phase 1, is it the IND? Is it the dosing of the first patient? Or if it's completion, what is completion? There are various steps towards those things. And if your agreement is vague, you know, you may find yourself in an argument with your licensee.
I just wanted to interject one thing here, and that is what she just said about completion. I've got an ICC arbitration pending right now where that issue has been fought in Delaware and before the arbitration tribunal. What was a phase 1 trial completed, capital C. It was even defined in the contract, and it's still a source of fighting about it. So again, be as clear as you can be.
Right. Yeah, and another one is also financial, because sometimes we have financial milestones. We have to prove that a certain amount of money was invested in a company. So as life has evolved and business has evolved, we have all kinds of investment vehicles. It's not only clearly equity. So is a CLA, is that an investment? What about a safe? A safe is a form of a loan, in effect, that really is equity, but there are no shares. It also comes up in context of dilution, which makes a lot of dilution formulas, don't work because of that. Do we take grants into account? It would be best to actually spell all those things out. The next place where, number 6, where you often find ambiguity is in the section that deals with milestone payments. So here I'm not talking about diligence. I'm talking about when a lump sum payment is triggered. And here, you see a lot of arguments and lack of clarity. Is it due more than once? And if it's per product, what is, especially in the life sciences field, what is a new product? Does it mean that you need regulatory approval for it? Can it just be a new indication? What is a new product? So all those things, again, require a lot more attention in drafting.
Yep.
You want to add anything about that, Conna?
No, we can go on to the next one.
Okay, so go on to number 7.
Number 7, one of my personal favorites, sub-licensing income. So let me just define what that means. I'm sure many of you know, just to make sure. So you have a license, you're the licensor, and you license to the licensee, set the royalty rate, have milestone payments, but you also permit that industry partner to sub-license the rights to another third party. That's very common, and it's important because often the company that takes the initial license from an academic institution is going to be a relatively small company, and they'll do some of the clinical trials and some of the research, but then to really go into, say, in a pharma product, and this also comes up in all the life sciences, to the next phases, a phase 3 trial, which is extremely expensive to run, or the equivalent for a diagnostic or a medical device. They'll want to, and as they're approaching commercialization, where you really need the big guns of a bigger company and their sales force to get the most out of the product from a commercial perspective, they're going to sub-license it to a bigger company, a bigger life sciences company, and that's all good. That means they're trying to make sure that the commercial potential of the product is fully realized. So licensors, academic institutions know this, and they will ask for a percentage of the sub-licensing income. This is a source of so many disputes that I have dealt with in mediation.
Nobody likes to pay.
Yeah, nobody likes to pay. Mediation and arbitration. And the big issue is, and this gets back to the academic versus industry perspective that I opened up with in connection with my remarks about the perspective of the companies. The academic institutions say, we came up with the idea, and you would never be able to make any money without our idea. The industry partner says, well, but we wouldn't have been able to commercialize your idea without our investment. And by the way, along the way, as we've developed things and learned how to manufacture the product, we've also added patents to the patent you gave us. And there's a bundle of IP that is necessary to commercialize this product. So it's not just your patent, it's your patent plus all the other patents that we brought to the table. So I've seen a couple of times an industry partner, without it being expressly permitted in the agreement, saying, all right, the sub-licensing percentage that the licensor gets, the academic institution gets, is 5% of sub-licensing income. But I'm going to say it's 5% of 10% of the money that I'm getting, because really the patent from the academic institution was only a small part of the bundle of rights necessary to manufacture and commercialize this product. So they impose an allocation formula that was not agreed up front. All I can say about this is, please, this is one of those definitional issues. I know there's been a lot of progress on the definition of sublicensing income. You know, the sophisticated institutions include things like equity, right? Because a lot of downstream deals include getting equity instead of just money. So that's great. But I would say also, have a very upfront discussion with your licensee about what happens when other IP, other patents, or additional know-how is necessary to commercialize the product. Just talk about the issue, because then you will avoid an industry partner just seeking to allocate value. It needs to be an upfront discussion. It might be an unpleasant discussion and it could be difficult, but there are formulas that you can use to figure out how to allocate value across patent portfolios. Experts do this all the time. You could say, have a provision in your contract that if an allocation exercise is necessary, both parties will hire an independent expert to do that allocation. There are lots of things that you can do, but don't be silent about it, because companies may do it anyway, and you will have to deal with that down the road. The end.
I've been warned that we have 5 minutes left, and even though we have another 3 topics, I wanted to ask if anyone has questions.
Right.
Because we won't have a chance afterwards.
Right.
Does anyone want to ask anything? Okay, so if not, then we'll continue.
We'll race on, and also we can be available for questions by email afterwards. Okay, yeah.
Yeah, of course, of course. In any case, the next topic we sort of touched upon is development reports and audits. I think we already discussed that.
We did that, yeah.
We did that already. And then the next one is the effects of termination, which Conna will tell you are typically grounds for litigation. So
Yeah, I mean, just really quickly, a very important part of any contract, we said this before, you have to assume that there may be situations where it doesn't work out and you have to terminate the agreement. The effects of termination clause, there should be a very clear effects of termination clause. Who gets what data? Is there a grant back of IP to the institution? What you can use that for? Let's just leave it at that, because I've seen so many arbitrations and mediations come out of the termination of an agreement without clear indications or allocations of rights. And that's a sad thing, because you can deal with that up front.
Yeah, I wanted to mention in that context that something I've seen that's often overlooked is what happens to joint patents, because from 2 aspects. First of all, the law is different in each jurisdiction as what the rights of each owner are. Under US law, a joint owner can make use of a patent within the United States without the consent of the second owner or other owners, whereas in Israel consent is required. Reasonable self-use is allowed. Another issue that comes up in that context with research institutions is that even if there is such a surviving joint patent, the research institution may not necessarily want to pay the cost of keeping the patent alive while it knows that its co-owner is making some use of it. So that could be an unpleasant situation, which I think people don't give enough thought to. Okay, so our last topic is the right to publish. Obviously, there's an inherent conflict between academia and industry as to the right to publish and confidentiality. I mean, it comes up a lot more if there is sponsored research and ongoing research, and again, a researcher wants to publish his work. One thing I think that also is overlooked is in the context of hospitals. I think that I wonder whether an investigator-sponsored clinical trial is considered internal research or not. That subject has come up of late. So, Conna, is there anything? Okay, 2 minutes. Okay.
That's right. Well, I can, you know, I'm a native New Yorker, so I can talk really quickly. I would say that confidentiality is often an issue that comes up in mediations and arbitrations, misappropriation of confidential information. It kind of functions like IP, right? Confidential information, it is almost a contractual patent right to some extent, or a trade secret, for example. And I would say that really one thing to remember is that all confidentiality obligations involve two things. It's not just don't disclose it to a third party, it's don't use it for any purpose other than the purpose for which you were given the confidential information. And big companies and institutions forget about the use restriction all the time. Often institutions are permitted to use the confidential information for internal research purposes. You should make sure you have that. But I've seen many mediations and arbitrations where researchers have taken information and said, oh, this is interesting. And they started working on something else within the institution that ultimately ends up being licensed out. And there is the problem, right? Again, it's all about monitoring and making your researchers aware of the restrictions on their ability to play with and research in a wonderful academic, inventive way, the information that they get in from industry partners. Period.
Okay, so anyway, I want to really thank you all for coming. It's such a pleasure to actually see you all in the flesh, so to speak. And it's a shame that Conna couldn't make it. Conna, we invite you to the next ITTN conference.
Oh, thank you. I'll come.
Fantastic.
And if you have any other questions that you would like to ask me, my email is cweiner@jamsadr.com. That's cweiner@jamsadr.com. Yael has my information. I love thinking about these issues, and I always learn from you all about what you're thinking about and the disputes that you're dealing with. I have an academic interest in the field, so I'd be happy to answer any other additional questions. And thank you for having me.
Enjoy London. Bye-bye.
All right. Thank you very much. All right. Bye-bye.
Bye-bye. Connor's at an arbitration in London instead of being with us.
Yeah.
Bye-bye. Bye. Yeah. Yeah. Ah, okay. You're not a patenting?